So what do you do? Let's say we go ahead and say, please put that away, and the person does. But you still know. How do you get that phone to the higher power? Don't tell your principal that you call them a higher power. I don't think they need that ego. But let's face it, they are contractually obligated to do different things from classroom teachers, and this might be one of those things. And don't overthink that. How do you get this information to the teacher or to the principal?
I think it's just having a conversation with them and saying why you had that suspicion and what evidence you have.
Yeah. Hopefully, the principal's pretty good at taking you at your word as well, right? This is all part of the game. If you're now visualizing yourself on a cop show, because you always really wanted to be a criminal lawyer, this might be our only adventure into this sort of law, right? Be good about it. We have a chain of evidence thing, don't we? Because if you're not reliable informants, you like that word, don't you? A reliable informant. If you're not going to be good at this, then I might not be able to take, use, investigate, right? So thank you for being reliable. So far, so good. And then the principal then can seek out this student, correct? I don't mind any of that. Now, can you help me defend an exception to all of this that said I could have confiscated it from the start? Even though that's not the normal protocol.
If there's any suspected immediate danger.
Yeah, any suspected immediate danger. Now, I don't know what exactly cyberbullying is going on. Maybe my overhearing didn't have enough to say that that there is immediate danger, but there's still stuff. I don't even know yet whether the material that's floating is real, is from a week ago, just happened, right? So I'm okay with this because I like that. If I asked you, are you prepared to defend the decision you've made? See, Ms. So-and-so took the phone against the policy because the policy was keep it away, and that's the normal practice to ask, right? But we've gone above that. If you've gone above normal practice, I'm going to need you to defend what you've done. Do I find that reasonable? Mm-hmm. I do. That's, even if it's not an explosive, because there's probably not, or maybe it's not one of those sorts of things. I don't know. Cyberbullying. What could that be? Could that be some picture snapped in a locker room that's now being paraded around underneath the desk all the whole? Is that imminent danger? Could I defend that, even though it's not a weapon or a drug or an explosive, right?
We're protecting the mental health.
Yeah, and so could you say something like, I was protecting the student, Your Honor, if called? Oh, yes, yeah, I think so. I think so. And it's not because we like to invade privacy, right? We're balancing privacy with what? Go ahead. Security. That could be sometimes school security, right? School-wide security. What else? I balance an individual's privacy with everyone else. Yeah. What I like about constitutional law, as we see it, and this is a constitutional law question, is in constitutional law, especially inside education law, as I've seen it, it's about the balance between individual rights. Here we're talking about privacy inside a cell phone, right? And either the rights of others, which this would certainly apply, or the good of the whole, right? If it's a bomb threat through cell phones, that's serious too, right? Even though it's not a picture of somebody, that might be enough for me as well. They could be hacking the systems at school from their phone, right? I mean, any number of things. It could be a list of people that are involved in a drug deal, right? So lots of things could happen on a cell phone. And honestly, this question, poor thing, would never have appeared on the list when Dr. Garlow and I first met, because we were talking about that quite so much. Now we kind of are.
Correct me if I'm wrong, but in the state of Ohio, not all schools have to have an anti-bullying policy.
Yep. Yeah, no, we have, do I have something in, it's under student discipline. A little bit in number 6. Yeah, so all schools in Ohio have to have a policy on anti-harassment, anti-bullying, anti-intimidation. Those are the 3 words that our statute uses: harassment, intimidation, and bullying. All schools have to have a policy on such things. And what I really like about it, you will find inside the Ohio Revised Code the word electronic. The first round, the first edition of this law gave a definition of bullying, and it didn't have the word electronic in it. Now, I will argue that it would have applied anyway, but I don't mind it when sometimes I do mind what legislatures do, just saying. But when the legislature came back and added the word electronic and then a couple other related terms, it said to me that society understands what we do every day, right? Because it gives us that authority. This is why I think couple steps away from normal practice under the circumstances could be defendable. And obviously I'm hoping the principal comes to you, I thank you for bringing this to us with such prompt attention. But actually, I like that. I actually want you to act comfortably and confidently in such circumstances, because you're going to be that first ear, right? You're going to be the first one to overhear, and we're going to need you to help that out. It's very, very, for me, easy and also protected, because the law, court cases, right? Courts are going to come back and protect you as well. The legislature, in effect, already has, and I'm glad for that. So will those courts come back and say, essentially, thank you for doing your job. Obviously, we don't need to keep the phone forever, so there are limits on that invasion of privacy, right? We need to keep it for a while. We have to record some evidence, that type of thing. But for the most part, maybe the person will get the phone back eventually. If it turns criminal, well, that may be a different story as well, depending on what exactly is on it. A couple, any other questions or thoughts on that?
I have one. So most people have certain security locks on their phone. So if you confiscate the phone, how can you get the student to unlock the phone so you can see the evidence on it?
No, if I don't get into it fast enough, it'll time itself out, right? How do you do that? That's a sure confiscation. I'm going to keep the phone. If the student refuses to open the phone, whether you are the teacher or whether you're the administrator, let's answer a quick question first. If you confiscate a phone, and that's within your authority, and most often it will be because the classroom teachers are going to be the ones closest to cell phone violations, you are allowed to confiscate. I would prefer that the teachers not do the searching inside the phone. If it is not open, if it's not in plain view, it doesn't yet belong to you. So your job is to keep the phone and hand it to the authorities. Then the principal, if it's criminal, if you have a police, law enforcement relationship, security officer type, those people can come in and help as well. But please don't open the phone. If it's not there in plain view, it doesn't belong to you. Ah, yes, but as I was carrying it to the principal, it buzzed. And I had to look because it's an involuntary body function now. I know it wasn't my phone, but I looked. That's okay, because it's in plain view, right? But if it's not. So, principal asks the student, open your phone. The student refuses, my mom pays my bill. It's not really my phone. Whatever the excuse is that the student has offered, raise your hand for it. So,
Yeah, I was going to say the next step would be contacting the parent, because they have to also look at the phone. Like you said, they pay the bills.
oh yeah.
If they don't know, they can guess it.
You'd be amazed at the level of consent that is offered by parents over the phone when their kids are in the office. Maybe you wouldn't be amazed, but it happens. And don't. There's a goodness to that. That sounded a little bit more jazzy than I probably needed to sound. But that's there's some goodness to that, because that's proper protocol as far as I'm concerned, right? Do we still at that very get-go have the evidence to have that kid in the office? I've seen nothing yet, heard nothing yet that says we have to release this child back, right? Everything so far makes me comfortable. So I'm good so far. Yeah, and you call the parents. And I don't know, maybe I do know what the bullying is. Is it mild name calling, dirty joke telling, or is it really a locker room shot? Is it evidence of drug dealing? And you know, the closer to criminal it gets, the more you get to keep that phone. And sorry to say for the kid, the more you get to keep that kid, right? There's a detention coming. Does that sound fair? A la detaining, right? Yeah, I think it is. And do I like all that? No, actually, I want all kids to follow all rules and love Shakespeare. But there's there are some of those moments where we do need to balance privacy with good of the whole. And I like what you have offered so far on what your role is in it, right? That's, if I came in here hoping for a comfortable, confident line draw, you gave it to me, that's great stuff, right? And honestly, questions 2 and 3 follow, especially number 2, fall right in line. What legalities are involved in accessing a student's locker? Let's compare lockers to cell phones. Tell me about the privacy expectation. Yeah.
Well, I would say that, oh, sorry.
Go ahead.
I would say that lockers are kind of owned by the schools, so it's even less.
Same.
That's, yeah.
Yep, lockers are owned by the school. The expectation of privacy in a locker is far less than it is in a cell phone. Why is that important for us? Why is it important for me to measure the privacy expectation in a locker versus a cell phone?
Because the contents will requirements of the school.
Yeah, the contents in the locker then need to be within the rules of the school, the expectations of what you might have in a locker. That's one thing for sure. What else? If I balance privacy with good of the whole, and I've already reduced privacy, what does this tell you about the authority to maintain the good of the whole? Right? If privacy is a smaller piece to this, then it seems to me that the good of the whole gets a little bit more credit. In other words, I can probably search a locker for more things than I would be able to search a cell phone. Right? Because if I'm going to invade privacy where there's a higher expectation of privacy, then I better have a really good reason to get in there. Follow? Right? If I'm going to confiscate and search your phone, essentially against your will, even if you consent, I better have a really good reason to get in. Lockers, there's a law in Ohio that says we're required as schools to post a sign on or near the lockers that reminds students that the lockers belong to the school and are subject to search at any time. That already tells me the expectation of privacy in a locker is relatively low, right? I hope that works for you, right? There's other things we can search: cars, backpacks, underwear. I have to say that, my gosh, oh, the number, oh, please don't do this, please don't do this. There are, it's amazing what schools will go to find a missing pin. I've read a few court cases. Don't do this. Right? The whole, no. Thankfully, no one I know, no BGSU grads, nothing going on in Ohio with respect to strict searches in public schools. No. Random, what about randomly? Your analysis drug test, what about the random test? Have you gone to or work in schools that have your analysis drug tests? Who do they apply to normally?
Athletes.
Athletes, you were going to say?
Athletes and people with cars.
Athletes and people with cars. People with cars. See, cars are movable. Cars are movable. If I suspect something in a car, not just in your urine, by the way, but in a car, what's the expectation of privacy in a car? It's a personal belonging, right? It's different from a locker, so it's going to be a little bit higher there. But cars are also movable. So the urgency might be a little higher too. Yeah, sometimes what would justify a random urinalysis drug test for people who drive to school? What would be your justification for doing that? I've read the justifications for the athletes. Yeah.
I would say keeping people safe in the future if something happens to your health and you crash.
Yeah. Driving under influence is clearly discouraged. So if we are going to allow students to drive to school, then perhaps we are allowed to subject them to other rules that don't always apply to everyone else, or that don't apply to everyone else, right? Are you giving up some of your privacy for the allowance to drive to school? Mm-hmm. Same thing with the athletics. Now, I don't know if I'm personally in favor of random urinalysis drug tests for people who drive to school. I don't know if I would advocate a policy that goes that far, but I suspect if it were challenged with that sort of rationale, it might hold up. I know that the drug tests for athletics and other extracurriculars they've been upheld in courts at the Supreme Court level on a couple of occasions. So that I know. Still not so sure about the driving to school, but I know there are some policies out there that have yet to be challenged legally, right? But we have good rationale. Are you prepared to defend the decisions you've made? I would ask that same thing of a board, not just of a teacher, right? So if a board of education is going to adopt a policy like that, I would want them to have asked that question. Is the Board of Education prepared to defend the decisions it is just made? And I'm hoping they will. I want to move on to a few other things too. As I'm battling and you're looking through, my gosh, shout out a number. Please do 17. Okay, go ahead. Number 3, can teachers legally access student records and discuss issues they may be concerned about with other personnel? This is a really important question, I think, not something that you might even think about until you're on the spot. So what do you think about this? Accessing student records and discussing issues they may be concerned about with other personnel in their school. All horrible reputations about teachers' lounges aside. You chuckle, see all you're smiling because you actually can't wait to get to the teachers' lounges. I'm sure you're wondering what's going on in them. Yes.
It's okay to access them, but I don't think it's like okay to like talk about like which student it is, like their name. Like I don't think you're allowed to say their name out loud. Like you're not allowed to discuss what they had.
And I would argue that there's an it depends to that, but I like the first thought. I think the first thought ought to be, the first thought, which is yours, and I like it, ought to be, these records are student records and kept confidential for a reason. Let's do that, right? Thank you. And yes, you would have access to the records of students. Now, what parameters would I have on what records you can access? What records would you be allowed to access as a classroom teacher? Don't overthink this.
Education records, discipline records.
Go ahead.
Of your students.
Yeah, the students that you would have contact with. That might be in your classroom. It could be if you're a coach, right? So you may be able, you would have access to records of other students you would have contact with, right? Perfectly fine. And that's good. You would need to know these things possibly because of those academic records, the discipline records, and even the medical records, right? The allergies, the medicine dispensation times during the day, these sorts of things, right? If the child's got a disability, the IEP, right? These are academic or education records that you should also have access to.
Would it be acceptable to talk with another teacher about it so that we both have to create a plan of action?
Yes. Yes, and that's part of the it depends. I still like the baseline, but now we can talk about, so what are the professional and lawful uses of such records? Easily talking with another teacher about setting up an intervention plan or whatever it might be for a student that you know both teachers have. That sounds fair. What about, I'm sorry, go ahead.
I was just gonna add to that, I think it should be done in private, I don't think it should be done in the teacher's file.
There you go, yeah. There are plenty of other workspaces, I'm hoping, I agree with you. Because that maintains the confidentiality that you already know should exist, right? It's not anonymity, you do have to know who the person is, but it is confidentiality, and I appreciate that. What about if that other teacher were the teacher of this kid last year? 2nd to 3rd grade, or whatever it might be. What do you think?
You can see how they help with the problem. Like if the student is having trouble paying attention to class, you can see what they did and if it was successful or not.
I have no problem with that. But were you gonna say something similar?
Yeah, I was just gonna say, like, C, like,